welcome. Thanks for coming. Thanks for coming to today's seminar on estate planning for Massachusetts residents. My name is John Kendrick, and I'm the chair of the endowment committee here at First Parish Church at Stow and Acton. It is sponsoring today's seminar. A couple of logistical items. First, in case of a fire or emergency, there are exits over here and at the back. Secondly, in a different type of an emergency, there are restrooms down the hall to the right. You can laugh now. And then we do have food back here for a mature kind of emergency to get hungry, or a little coffee compliment to Jeff Brown. Thank you, Jeff, in the back. Today's seminar on estate planning could be important for anyone of any age who's thinking about estate planning. It's the first of a four-part seminar series that we're calling Senior Concerns. That's taking place today and for the next 3 weeks here at FPC in the Fellowship Hall at 1 p.m. We're going to cover topics of concern for people who are looking ahead to retirement and people who are already retired, because there are still decisions that need to be made once you're retired. I'd like to thank the other members of the endowment committee, Beatty Weeks, Lori, pronounce her last name wrong. Lori, how do you pronounce her last name? Lori Prue, and Tom Moses, who was last year's chair, for their work at putting this series together. I'll remind you again at the conclusion of the program that the upcoming topics are going to be next week, October 1st, Medicare and Social Security programs, followed by the next week, senior living options in the Metro West area on Sunday, October 8th. Finally, local services available to seniors on Sunday, October 15th. Today's presenter is Barbara Epstein. She's an attorney with Scheier, Katin Epstein. Barbara is going to provide an overview of the key elements of creating and updating an estate plan, including a will, a trust, a desire, durable power of attorney, and healthcare directives. Barbara will address the implications of the Massachusetts estate tax, which is different than a lot of other estate taxes around the country, and ways to effectively include philanthropy in your estate plan. Barbara joined her firm in 1999. I don't think it was called the same as it is today, right? That's not like
one missing.
This is her left hand. She focuses her practice in the areas of estate planning, estate and trust administration, planning for beneficiaries with special needs. She works closely with individuals, families, and their advisors. Very importantly, we guide them through the estate planning process and negotiate the difficult, practical, and emotional decisions that might arise. And finally, before turning the microphone over to Barbara, a very quick message from the endowment committee as sponsor of today's seminar. We hope that all of you, members, friends, and community members here might consider including FPC in your estate plan, if that works for you. The endowment here is very important part of the financial health of the church, helping to keep it strong for future generations. And so any support that you give, or that those of you who have already provided for in your plans, is greatly appreciated. Thank you. And now, let me turn it over to Barbara.
Thanks.
All right, thanks. Thank you all for coming. I hate microphones. So raise your hand if you have any estate planning documents in effect, will, powers of attorney, anything. Okay, pretty good. That's a good start. And probably for most of you, maybe most or not all of this will be stuff you know, but hopefully you'll learn something today. So there's a lot of misconceptions about estate planning. Some people say, think that if you don't have a large estate, you don't need anything, and that's not true. We'll talk about why, but estate planning usually includes planning for incapacity and planning for when we all go, which happens to the best of us. A lot of people also think that if you have a will, there's no probate, and that's not true either, and we'll talk about that. People also have all these misconceptions about the state taking everything. I mean, even if you don't have a will, if you have any relatives at all that anyone can find, the state isn't going to take anything. well, Medicaid is a whole other thing if you get certain benefits, but in general, it's just not true. And also people think you can't gift more than 17,000. It changes every year. It used to be 10 and it goes up every year, but people think those numbers are a number beyond which you cannot give money, and that's just not true. There's just certain things you have to do if you want to give away more than that amount of money in a year. So we'll talk about, oh, is that better? All right, sorry, thank you. We'll talk about all of those a little bit more. First, planning for incapacity. Given this crowd, I'm not going to put a lot of discussion into appointment of a guardian, although sometimes people need a guardian for an incapacitated person too, but in general, that's something for a minor. And that's usually done in a will, although there are specific documents, like if someone's going away and they want to make sure that someone, while they're gone for a few weeks, can make legal decisions or temporary appointments for a guardian, but we're not going to talk about those today. Durable powers of attorney, that's the appointment of someone to make financial decisions for you, and there's different types. They can be effective immediately, or they could be effective only when someone actually becomes incapacitated, and we'll talk about more of that. And then healthcare documents. There's a lot of different names to healthcare documents, healthcare directives, powers of attorney, living wills, and we'll kind of talk about what the differences are and what is actually the law in Massachusetts. And then there's lots of different kinds of trusts, which can be funded, can be funded, is this working? Okay, can be funded during life, so those can also be a vehicle for planning during life, not just at death. But trusts are very broad, and we'll talk about different kinds of trusts and what their purposes are. All right, planning for death. Wills, everyone knows what a will is in general. Trusts. Real estate ownership and transfer options. So oftentimes the way real estate is owned dictates what happens when you die. So if you're joint owners of various types and one person dies, it's pretty much automatically the other's property. Sometimes you have to file a death certificate, but that tends to be a vehicle for transferring the real estate on the first death, at least, with a married couple or any kind of joint owners of real estate. Of course, beneficiary designations on things like retirement accounts, life insurance, those pass. If you have beneficiaries, those pass according to the designations, regardless of whether you have a will or not. If you have a primary and secondary beneficiary, that usually takes care of itself, as long as those beneficiaries survive you. I'll talk a little bit more about that. And there's a lot of different kinds of charitable giving options. Some are encompassed in the above, like in a trust or by beneficiary designations. Then there's other charitable vehicles, which we're not going to talk a lot today, but there's charitable foundations that I'm sure you all hear about. I mean, some of these are for very, very wealthy, but there's some others that are becoming more popular, such as donor-advised funds. I don't know if any of you have heard of that, but we'll talk about that a little bit too, as a way of giving to charity. I don't know. It's just a little funny. Okay. So durable power of attorney. Does everyone have a durable power of attorney? Raise your hand if you think you have one. Okay. So durable powers of attorney. So there's different kinds of powers of attorney. There's a power of attorney, and then there's a durable power of attorney. So sometimes if someone's going to be away for a real estate transaction, they may give a power of attorney to their attorney or to their spouse, so they can sign legal documents for them for a specific reason. But a durable power of attorney is a more general document that gives the power to another individual to pretty much do anything that you could do. So with a durable power of attorney, the person that you name as your agent, and even though it's called durable power of attorney, it has nothing to do with an attorney. It's usually your spouse or maybe your kids or your neighbor, whatever that you name, but it gives that person the power to act financially in any way that you could act. So it's very powerful. They can change, in theory, they could change the beneficiaries in your retirement accounts. They can transact business in your name. That's all theory. These days, I find that more and more financial institutions, they're often don't love accepting these. Many, if you try to use a durable power of attorney, like Fidelity, they'll say, oh no, you need to sign our own form. Well, the problem is that oftentimes when someone does a durable power of attorney, they do it as part of an estate plan, and 10 years later, when they can no longer sign for whatever reason, they have, it's some sort of incapacity, and now their kid, who's named in the durable power of attorney, wants to get money out for their care or whatever it is, and they go to their advisor and they say, oh, they need to sign our durable power of attorney. Well, the reason we did this planning is so in this case, we would have the right documents. So sometimes you have to actually put up a little bit of a little stink, because I've seen this happen a lot. And sometimes you can sign their own form. I mean, you're still fine, and you're capable of signing Fidelity's form, naming the same person that you're named in your durable power of attorney. But sometimes you can't. Your mother, your parent has dementia, and you're helping them with their finances, and now Fidelity is saying, well, even though she has this durable power of attorney, she has to sign our form. Yeah, sometimes it doesn't work very well. Here, go back a little. So when I do them, I do a primary and a backup. Most people do that. Some don't. Sometimes someone comes to me and they only have one, and it's good to go at least 2 levels. You could go even more if you want, but at least you have a backup on there. It's particularly important for people who are not married or non-traditional couples, because oftentimes you might have everything is joint, so you don't really need a durable power to get, say, money from your joint account, but it does allow you to access someone's individual account. So like retirement, like I said, retirement by definition are individual, and if you have a durable power of attorney for someone, in theory, you could take extra money from their retirement if you need to, for the care, you need more money out of it or something. Durable powers of attorney can be effective immediately when they're signed, so it doesn't have to be effective only upon incapacity. Usually for spouses, they're effective immediately, but it's a checkoff when I do a form. Or they can be effective only upon incapacity, so it could only be used with a doctor's letter of incapacity. So you need the durable power and a doctor's letter in order to use it. That's called the springing power. Okay. Healthcare documents, lots of different kinds. In Massachusetts, we usually do a HIPAA release. That was, when I first started practicing, there was no such thing, but HIPAA is, I guess it's not so new anymore, but we do a separate HIPAA release, naming whoever you name as your healthcare agents to also be able to get information from you, because with a healthcare proxy, which is a state form that you might sign just when you go for an elective procedure, it doesn't necessarily allow that person that you're naming to get your personal health information. So if you have a HIPAA release in addition, that will allow them to access your health records. Healthcare proxy, like I said, it's the form that we do is actually the form that you get from your doctor. You could get when you go to the hospital for any kind of elective procedure. But it's good to have, because if it's not an elective procedure, you want to have one in advance. A healthcare proxy names an agent to make your healthcare decisions. It does not lay out situations or specifics about what kind of care you might want. That would be a living will. A living will is more specific than a healthcare proxy, and it's not legally binding in Massachusetts. So in Massachusetts, it's the decision of your healthcare agent that the doctor would generally, unless it's kind of a crazy decision, but in general, your doctor will abide by the decision of your agent. If you have a living will, which says I may or may not want certain life support or things like that, it's considered an expression of your wishes, but it's not legally binding in Massachusetts. One of the forms that I had there was the 5 wishes. So 5 wishes is a form of a living will. It's something that you could actually fill out on your own if you don't already have. Something similar, the first wish in there is your naming of the agent. So there's a naming of an agent and a backup, and then there's more specifics about what kind of interventions you may or may not want. If you decide to do that, if you don't have anything, if you don't have your own healthcare proxy or living will, you just need 2 witnesses in Massachusetts who are not named as your agent. You don't need a notary or anything on that form. Organ donation, that's something that I don't really participate in. I guess it's usually on your driver's license or when you sign up for your driver's license. Maybe also when you sign up for voting these days. I'm not sure. DNR, DNI, those are usually done with a doctor in a hospital. I don't do those forms. Do not resuscitate. Do not intubate. MOLST form. Has anyone heard of MOLST? MOLST. Well, that's probably because your doctor doesn't think you're elderly yet, so that's good. When I brought my mother up here from Florida in 2017, and I took her to, I moved her here, and I brought her to a PCP for her first appointment. And the first thing they did is say, look at this form. So it stands for, I thought the M was Massachusetts, but someone told me it's the same form in another state, but it's Orders for Life-Sustaining Treatment. And what it is it's a form that has to be done with a doctor. And it's similar to some of these, like it has do not resuscitate language in there, and some of the living will language, but doctors do it and they sit with the patient to kind of make sure that they understand. And so it's good that none of you guys have it yet, but at some point you might. The doctor, my mom did it. She had the early stages of dementia, but she still understood enough to fill out the form with the doctor. Yeah. All right. So I talked a little bit about this already, I think, the living will versus the healthcare proxy. You need a healthcare proxy. The living will, you need it. You should have it. Living wills are really meant more to help your agents know what your wishes are. So often for spouses, you kind of know what the spouse might want, but sometimes for your kids or other people that may be your backups, it may not be so clear. So it's really helpful to have that. In a lot of states, it's actually a living will that's binding, and they don't have, the healthcare proxy is specific for Massachusetts. But it makes sense to me because the healthcare proxy just names an agent, and you don't really know all the eventualities that might happen. So to try to say, if this happens, I want this, if this, it could be helpful, but you can't really hit all the possibilities. So, by the way, if anyone has questions, you're free, especially if it's like something's not making sense, let me know. And there's also going to be time at the end. All right. So everyone who does any kind of estate planning needs a will, even if the trust is going to be your main vehicle, which we'll talk about later, because trusts are kind of will substitutes, but you still need a will. Because even if you do a trust and you think you're funding the trust and you're doing everything the trust, the will takes care of things that kind of fall through the cracks. Also, if you have minor kids, the will is going to name the guardian. The will also generally names who's ever going to take your personal items, who go through your stuff, could probably access passwords.
Sorry, I do have a question. I think we have some that are like 25 years old. So how often do you recommend refreshing?
Did I do you really look very familiar? You might have, yeah. Oh, 25 years. I think I've been practicing for about 24 in this firm.
Good start.
Yeah, that too. I know you're from town. There's no rule, really. We tend to tell people to review every 5 to 7 years because laws change, your circumstances change. You probably didn't put your kids in a lot of these roles that we're talking about, but now they're adults, so you probably want to change it. So there's a lot of different. So we say every 5 to 7 years. Many people do every 15, 20 years. When you look at your documents and you say, oh my God, the person that I chose for all of these is like no longer with us, or not the person I want anymore, or my kids are, I needed to name a guardian because they were 1 and 3 and now they're, 25. So there's a lot of different reasons, but I would say you're probably overdue. 25 years. Yeah. So wills, usually name who's going to get your personal items. Also, the person that your name in the will usually is responsible for like tax returns and stuff like that, because the executor of your will, which is now called, people know the name of executor, but in Massachusetts under the Mass Probate Code, it's actually called personal representative, but it's the same thing as executor. That's the person who administers your will. The trustee is the person that administers your trust, and we'll talk about that. But I'm going to say executor because it's shorter than personal representative, a little shorter. So the executor is usually the person who has power to access like your tax stuff. Just by being named executor, they can contact the IRS once they're named, well, let me step back a little. Someone who's named as executor in your will has no power until the will is filed with a probate court. So that's why in the earlier misconceptions I said, if you have a will, you don't need probate. You still need probate because the will only names the person that you want, but they don't have any power until the court basically issues something. You file an original will, you file some other documents when someone dies, and then the court issues something called letters of authority, and that gives the person that's named as your executor the power to access your digital passwords, go to your safety deposit box, contact the IRS, and get your your tax forms if they haven't come. So the executor stands in a person's place when they die, but they're only executor. They're proposed executor or nominated executor until the court actually issues its own paperwork. But like I said, so probate is the process when you file a will with probate court, and then you get the court to basically bless, unless someone, says, when you file a probate, all the heirs have to get notification, and if an heir says, oh no, that person's a crook, or they're actually the one who killed whatever. I mean, there's certain reasons why a court will not will not authorize an executor even if they're named. I've never had that happen. I mean, I've never had anything contested when an executor files, but it does happen. So a will can be enough. I mean, there's certainly, you don't need a trust. There's certain reasons why it's better to have a trust, which we'll go over, but if you have a simple estate, typically for a married couple, upon the first death, will is usually enough. Certainly if you don't have real estate, a will is enough. If your beneficiaries are all over whatever the age of, legally it's 21, but I put 25 there, I'm not really sure. Maybe I think 25 you're more mature, but legally a beneficiary 21 and older can inherit directly through a will. Under that, they need a custodian, just like you would need a custodian to open a bank account for a minor child. You can't open it just in a minor's name and with no adult on there. And the probate of a will can be, it can take a lot of time. It's very unpredictable. So if you want money available immediately when someone dies, a trust is better, and we'll talk about that. But if you're not in a great rush, if it's not a huge estate, if the beneficiaries don't need the money like the next week, then the simple will is generally enough. Probate is, people hear horror stories about probate. I mean, probate can be a month, it could be years. I mean, Massachusetts, and sometimes it's a year, not because it's complicated, it's just because the probate courts are kind of a mess and unpredictable. So it really doesn't necessarily have to do with the complexity, how long probate takes, although, the more complex assets, the longer it would take, but even with smaller assets or simpler assets, it could take a year. I don't think I've had one take more than that. And as I said earlier, if you have minor kids, the will is where you name the guardian. Okay. I'm not going to spend a lot of time in this, but,
I just want to offer just a couple of comments that have been to estates today.
can everyone hear her?
I understand that if you're dealing with a younger person, these things because they're not for assets, they don't, that's a problem because they have bank accounts, et cetera, et cetera. So you have to have something in place.
You're talking about a...
Oddly, because it's when my brother passed away at 30, became ill. So that became a serious problem. So younger people who don't have a house or whatever think, well, there will be no bill. And they need some documentation to help. And also your comment about funding. My experience, and this is a past, I don't know, I'm just true tonight. If you want to do a funeral, you have to put money up front. And that's a challenge. That can be thousands. And if you have no access to any accounts, then you're going to get a lot of things up $500.
Yeah. No, I mean so like I said, and even if you had a will though, the thing is with your second comment about funds being necessarily, if you need them immediately available, even if you have a will, it's going to take, you're not going to have that to give the funeral home the day or the week someone passes. I mean, yeah, it's a problem. I mean, that's sometimes people do that by having joint accounts with someone, or if you have someone named as a beneficiary, or if there's money in a trust. Those are all very quick. In terms of age or asset level, I was going to talk a little. I think that goes in a little bit to this. People think that if you're not married or you don't have kids, maybe you don't need a will, but in fact, the rules of intestacy, and intestacy means someone dying without a will. The rules of intestacy are not intuitive. So if you don't have a will, if you're married and you have a will and your spouse also is the same person as the parent of your kids, then the spouse will get everything. But in any other situation, if you die without a will, it may not be what you want because it could be the parents rather than a spouse that has actually rights. If there's no kids and you're married and you have a living parent, your spouse then gets some, but your parent also gets some. So they're just really weird, counterintuitive, I think, rules of intestacy. So the bottom line is, for people who are not married, it's even more important in many ways to have a will because the rules are just strange. You have to find heirs at law. Sometimes you have to find distant cousins, and it's just, like people come to me and they're like, oh, it's going to be really simple because we got no kids. Well, it's usually not, because if you have kids, they're probably going to get almost everything. I mean, maybe you're going to name some charities, but it's usually more complicated if you don't have kids because it's going to be, this friend and this cousin and this nephew and maybe a trust for this nephew who has some special needs. And so less complex family or less, I don't know. Anyway, so these are just some really kind of strange examples. If you're married and you have kids and you don't have a will and you have kids from a prior relationship, your spouse is going to get some, and then your kids are going to get some. It's some strange formulas with the first 100,000 going to the spouse and then everything else getting divided. But if you share kids with your current spouse, then the spouse gets everything.
My question is, I did have a question. Is the microphone? If I don't have the question is, in Massachusetts, a will has no legal standing, as you mentioned earlier. So, if that's the case, why do we need a will? No,
That's not what. No. Not that it has no legal standing. It has no legal effect until it gets filed with the probate court. So a will by itself, that piece of paper that you wrote, it was your lawyer, if you die and no one can find it, or or it doesn't get, if it's in someone's draw, it doesn't have any legal effect until the probate court basically blesses it.
And then it does.
Oh, it does, for sure.
Okay.
Yeah,
So
sorry.
that's why it's important.
Yes, yes.
I think you were referring to a living will. It's not legally like
Could be.
that. Is
A living will, yes, that could be also. So a living will, even though it has the word will in it, is actually a healthcare document. And a living will, which is like the 5 wishes that you have that you might have picked up, that's a living will. That is not legally binding in Massachusetts. It's just considered an expression of your wishes. Yeah, it's... But a will, yeah.
Yes.
Is that okay? Okay.
Yes.
Yes. Okay, so this is kind of, we've gone through a lot of this. When I say simple wills, this means a will without trust or without any additional documentation. So your question kind of goes to the last, what's your name? Yeah. Eleanor. So Eleanor, your question goes to the last point there, that delay or cost of probate could cause problems for survivors. Even a simple will won't be enough, but in your case there was no will, or in the case that you're talking about there was no will. So there's a delay. And honestly, if you have a very simple estate for a 30-year-old with a couple bank accounts and no real estate, the delay is probably the same whether they have a will or whether they don't have a will. Because you could probate without a will. It may not be the beneficiaries that you would want. Without a will, the state is going to tell you who gets the estate. But it's still, you have to go through probate, whether there's a will or no will. If there's no will, what's appointed is called an administrator rather than a personal representative, because they weren't named by a will. They were just named by someone who's petitioning the court to have power to act. Okay. All right, trust. This is where it gets really fun. So trust is a really, really broad category. There's lots of different kinds of trust. There's lots of reasons to do trust. There's lots of overlap in what people call trust. So some of the terms, there's actually testamentary trust versus what is more often called living trust. So a testamentary trust is a trust language within a will. So you have a will, but because there's minor beneficiaries maybe, you have a trustee named in the will who would take care of the money for the kids until they're 30 or whatever you decide. So that's a testamentary trust. It's just a term for a trust within a will. I very rarely do those, and they're not done very often anymore because they're overseen by the probate court. So a lot of the benefits of a trust, like money being available immediately for not having a cost and delay of probate, those benefits are, you don't get those benefits with a testamentary trust because you're going through the court with a testamentary trust. Sometimes, I don't think I've had this case, but if you want a court to oversee the trust, then you might want to do a testamentary trust because living trusts are not overseen by anyone. They're basically, unless a beneficiary protests, the terms of a living trust will go into effect and will continue unless someone has a problem. A testamentary trust is overseen by the probate court. Living trust, when you sign a living trust, it usually says this is immediately available, or it's funded with $1, or it's funded with $10. When a living trust is signed, it's like a legal, it's almost like you can think of it as a vessel that can hold things. So it's in effect, it's something when it's signed. You may or may not put anything into it. Often we'll deed real estate into a trust or name the trust as beneficiary retirement accounts because it exists upon signing. It has, in what Latin in legal terms is called a res, a body. And it's a living, breathing thing. Revocable versus irrevocable. Mostly I do revocable trusts. You could change them, you could amend them, you can, revoke them. Those are pretty much purely an estate planning vehicle to avoid or minimize probate or to manage money for minor beneficiaries or beneficiaries with special needs. Irrevocable or irrevocable trusts are primarily for asset protection. Oftentimes there's something called, there's a Medicaid irrevocable trust to basically get your assets out of your name in order to qualify for Medicaid. I don't do a lot, virtually no Medicaid planning. There's lawyers who specialize in just that. Medicaid planning, basically you have to get your assets out of your name over 5 years before you're going to need or think you may need Medicaid. And I don't do a lot of it because the rules are always changing and I don't want to keep up with them. And there are lawyers who specialize in them. And that's it's like a whole other, would be a whole other presentation really. I'm not sure it's a Medicare person that's going to be speaking, not Medicaid. Yeah, Medicaid, it's complicated. Wait, could you go back a sec? Life insurance trusts are also done. They're usually irrevocable. Sometimes you want to get assets out of your name, out of your estate for tax purposes. And so you can put them in an irrevocable trust, and after a certain amount of time, it's not considered your asset anymore, but you also can't use it. So they're often used for life insurance because life insurance is not for us anyway, it's for the beneficiary. So that's an asset that is often put in an irrevocable trust because you're not really losing anything by putting it in there, and you're getting it out of your estate, so it doesn't count toward your taxable estate when you die. And we'll talk a little bit about the estate taxes later on. Okay. Yeah, so a lot of people think that trusts are just kind of boondoggle for lawyers, but they're pretty useful. All right. I don't think I'm going to talk really any more about any of these. I talked a little about two of them. Qualified personal residence trusts. Sometimes people put like a family vacation home in one of those. It's a way of gifting and passing it on. After a certain amount of time, you no longer have control it. So some kinds of trusts are in order to pass on assets and not pay taxes. Qualified personal residence trusts are also a form of irrevocable trust. Charitable trusts, there's lots of different kinds of charitable trusts. They used to be a little more popular. I mean, at least with my clients. Now there's some simpler, less costly ways of giving some of your estate to charity without creating your own, a trust and having a trustee that's going to manage it when you pass. But those are options too. Okay. So this presentation was originally two presentations. There was kind of a basic estate planning presentation, and then there was kind of a charitable gifting presentation that we meshed, and some places it may not mesh all that well. So maybe a little choppy coming up, but try to combine them and do it smoothly as possible. Okay, so the main benefits of planning with trusts, and now I'm talking about revocable trusts. I'm not talking about irrevocable, talking about revocable trusts as an estate planning vehicle. The main benefits of planning with trusts are when you have minor beneficiaries or beneficiaries with special needs, or if you have a large estate and you don't think your beneficiary should get everything all at once, you can stagger payment. You name a trustee to manage the trust for your beneficiaries over whatever period of time you want. It could be till they reach the age of 30. It could be, until forever. I mean, and then you could do generation skipping trust, so to make sure that your grandkids get something. But that's probably certainly one of the most basic benefits of planning with trust is just to stagger and to have someone manage, and if someone might have creditor problems or might have other type of issues that you don't want them to get everything out right. So a trust has a trustee who manages and oversees the funds for the beneficiary. And they're very, very flexible. It could, like I said, it could be just till they reach 30, or it could be for the beneficiary's entire life. And that's something that's very adaptable in a trust. If you have a trust and you actually name it as beneficiary of retirement accounts, or you actually fund it during your lifetime, then you avoid probate. So when I do revocable trusts, I often put people's house in the trust. And what that means is when they pass, the house, in theory, could be sold like the next day. I mean, and if there's funds that are already in the trust, like investment accounts that are in the name of the trust, those are immediately available. You don't have to wait through the probate process. You don't wait 3 months or a year till you can access those. They're immediately available. With a house, having it in a trust is often very helpful to people, because if it goes through probate, there's no one that has legal authority to do anything really until the court issues its letters of authority. So if the family wants to sell the house, if it's in the trust, it's much more readily available. And if there's funds in the trust, they can pay the bills. Otherwise, sometimes they have to pay the bills with their own money during the probate process. So having assets in trust avoids or minimizes the cost and delay. It also can reduce or eliminate estate taxes, especially in Massachusetts. I think we're going to talk more about that. I think I have more slides of that one. Remove property from estate at current value. I don't even know what I meant by that. Let's skip that for now. Okay. So we've talked about, I think, the first one. If you just have a trust, if you do a trust and you do a will and you do the other documents that we talked about, but you don't do anything with the trust, so you don't fund it, you don't name it as a beneficiary in retirement accounts, you don't put your house in the trust, you don't name the trust as the owner of your brokerage accounts, then you're still going to have probate, because if the assets are not already in the trust when you die, they pass via the will. Now, your will might say, and often does when you have a trust, everything to my trust, but it has to go through probate, and you can't do anything. You can't do that until you file the will, you get the executor named and nominated, you get the letters of authority. So the trust is most effective if it's funded during life, not if you walk out of the lawyer's office or if you do your own trust yourself and you never fund anything. You still may achieve a lot of the benefits of a trust, like if you have the trust which says my kids this is a trustee that manages the money until they're 30, they get half of it at 30, the rest at 35, the trustee could pay for their education. That would still be effective, even if you don't name the trust as owner of the assets, but it would have to go through probate in order to get into the trust. So it's like probate, will, and then trust, and then the trust terms. So some of the benefits of the trust would still apply, but the avoiding or minimizing the cost of delay in probate would not apply unless you actually fund the trust during life. So it's really important, and a lot of people don't do that. I'm surprised sometimes that people who've worked sometimes with really big law firms, they have all the right documents, but they haven't done the follow-up, and it's really important to do a lot of stuff besides have the documents. The documents are just part of the process. And that's another reason why when you ask how often do you check it, do you review, you review, especially when you have trusts, you want to review probably at least every 10 years, if not more, because it could be that when you did the documents in 2010, you named the trust as a beneficiary of your retirement accounts and your life insurance and put the house in trust, but you moved and you have a different life insurance policy, a different retirement accounts, and you don't necessarily, each time you get a new asset, you don't necessarily think, oh, I should put that in my trust or I should name the trust as beneficiary. So reviewing every whatever number of years, make sure that not only you have the right documents and you have the right people named in the documents, but that the whole plan is effective with your assets the way they are currently. Okay. All right. So we'll talk a little bit about estate taxes. So this may put everyone to sleep, but try to stay awake. Or maybe it's really exciting. So I don't have that many estates that reach the federal estate tax exemption. Currently, $12.9 million doubled for a married couple. So, you know, if any of you are subject to that, well, congratulations. You should be doing a lot of gifting then and a lot of charitable planning. So there are certain ways of, you know, minimizing that, but I'm not going to talk about that. I don't get too many clients like that, a couple, one or two. But prior to like 2000 and, I don't know, 20 years ago when I first was practicing, the federal exemption was $1 million, just like, actually it was less than $1 million. And so a lot of people had to do federal estate planning, federal tax, estate planning, as well as Massachusetts. And back then, and even now, if you're subject to the federal estate tax and you go above those thresholds, between the state and the federal, it's 50% or so estate tax. So it's a big cut, but the exemption is so high right now. Massachusetts exemption is $1 million, and that's like, you know, a lot of our houses. I mean, so anything above $1 million in Massachusetts is taxed. Not with a married couple on the first death, there's no estate tax. If you leave everything to the spouse, it doesn't matter what the size of the estate it is. There's something called an unlimited marital deduction. So it's really, when it goes to the next generation, it's really on the second death that the estate tax applies. And then it's everything, life insurance, retirement accounts, real estate, your Picasso, that's all subject to the estate tax. There's been proposals like almost every year in Massachusetts to raise that Massachusetts estate tax exemption because we're the lowest in the country. I think Massachusetts and Oregon are the only ones that are still $1 million. Many states don't have any state estate tax at all, like New Hampshire or Florida. Many states have a higher, you know, more like $3 million or $5 million, but if you do some estate tax planning you could double the mass exemption, so you could have $1 million each. But if you're married and you leave everything to your spouse, like outright because they're joint on your house and they're joint on your bank accounts and they're named as beneficiary in your retirement accounts, you're using your unlimited marital deduction, so there's no estate tax. But when they die, they only have $1 million exemption. That you failed to double it. The way to double it is either on the first death to leave something to someone other than the spouse, which you probably don't want to do unless you have a lot more than $1 million, or to do some kind of trust where the spouse can access it, where you basically capture that first spouse's $1 million, you hold on to it, the survivor can still access it, but they don't get it outright. So by doing trusts or by naming someone other than the spouse, you can double that mass exemption. Let's see, okay. Was there a question? No. Okay. You know, and a lot of people try to, not just for estate taxes, but for income taxes too, try to change their residence. And this we'll talk a little bit about gifting too, because gifting is another way of lowering the estate. So, okay, I think I talked about everything on here. Uh-huh.
Can you expand more about on the last side of these?
Well, that's what I mentioned. So between spouses, there's an unlimited marital deduction. So there's no estate tax on the first death.
For U.S. citizens only.
That's correct for U.S. citizens.
What about
Correct.
what about legal residents, permanent residents?
Then, no. No, then you're subject to the, well, you're actually only subject to the federal exemption, which is $12.9 million. So probably okay. Yeah, the unlimited marital deduction for U.S. citizens is on the federal estate tax. Okay. Okay, so gifting and what everyone thinks is the gifting limit, which is now $17,000 per year. So raise your hand if you thought that you could only gift, well, maybe it used to be 10, 15, 17,000 a year per person. Raise your hand. Okay. Yeah, almost everyone thinks that. If you give more than $17,000 per year, you need to file a federal gift tax return, and it eats into your $12.9 million federal exemption. So if you give away $100,000 this year or $500,000, you tell the federal government on a form, I think it's 709 as a gift tax return. And now if you give away $1 million, now your federal exemption is only goes from 12.9, now it's 11.9 million. So does it matter? Massachusetts does not bring back gifts. So the federal government does. So it's a way of lowering your Massachusetts estate by doing large gifts. Now, I'm not saying everyone should go give away a lot of money because you don't want to give away appreciated assets. Do people know the rule? This is taxes. The term step up in basis sound familiar? So, Peter, if you have your house and you paid $50,000 for it, actually, let's not talk about the house because then you have the personal exemption. Let's say you have a stock that you paid $50,000 for and you go to sell it and it's worth $1 million. You're going to pay the capital gains tax on the difference. If instead of selling it, you leave it to your kids or someone else beside a spouse, their basis is now $1 million. So their basis is the value of that asset at the time of your death. So they're not going to pay that capital gains tax. And that's capital gains tax, 25, I think between Massachusetts and federal, 25, 30%. So holding assets until you die can be great for your beneficiaries because they don't have to pay that gain. The reason I bring that up is because if you gave away that stock during your life, you say, oh, I'm going to give this to my kids. I paid $50,000. Here you go. It's worth $1 million now. They take your basis. So when you gift an asset, the person you give it to takes the donor's basis rather than the step up in basis. So you don't want to give away appreciated assets during your life.
So my question is, if someone receives the gift, they have to pay income tax on the value above the, what is it, 17,000 of that?
No. If you gave away...
I'm sorry, current, before death.
Wait, I'm sorry.
Before death. If I give my kid...
$100,000.
Yeah. I won the lottery, give me $100,000.
And you have it in cash, so you're not selling a stock that's... Then they're not paying any income tax. They're not paying any tax. Nothing. That's not income. A gift is not income. You're going to tell the federal government, you're going to file that gift tax return and say, I gave away $100,000, and now what goes tax-free when you die is less by $100,000, but they're not taxed on it. No.
You got a quick comment?
Uh-huh.
You said giving away highly appreciated is bad to give to your kids because they keep the low tax basis. It's great to give to charity because now charity gets it and nonprofit organizations can sell that stock without paying any tax. So it's good to give the highly appreciated to charity, just not to your kid.
Yeah, so any highly appreciated asset, charity doesn't pay that gain.
Yeah,
highly appreciated assets include houses? To the state?
Mostly. I think most of our real estate is pretty highly appreciated, at least around here. Yeah. And you know, that's another thing that I've seen is sometimes people will put a house in their kid's name. They'll just, I don't know, if they get a lawyer or someone to do it, because it's easy to do. You just do a new deed and you file at the registry of deeds. Not a good idea, because you've given that away. They take their basis. They take your basis. Okay, maybe you avoid probate when you die, but now when they go to sell it, they're going to pay a huge capital gains tax, whereas if they inherited it, their basis would be the value as of the date of death. So it's not good to give away any assets that are valued more than what you paid, unless you get legal and tax advice, basically.
So, I know that's in, so in your example, this is on.
Nope.
In your example, where you put the couple's house in a trust during their lifetime, within the house has to their kids, I'm concerned that possibly the house wouldn't be eligible for a step up in cases due to the ruling, the IRS ruling, March of this year.
Well, maybe you know more about an IRS ruling. So depends. I am not familiar with that ruling, but depends on the kind of trust. So with a revocable trust, where if you're the donor or grantor of the trust and you're still the lifetime beneficiary of the trust, then that's not a gift. You haven't given away anything. It doesn't pass to your kids until you die. Depends on the terms of the trust. So you'd have to show me what you're referring to, because I'm not familiar with it. But I don't think it impacts revocable trusts where the beneficiary and the lifetime beneficiary is the grantor. If it's some form of irrevocable trust, it's very different. Or a Q-part. Are you thinking of revocable trusts?
I'm thinking of the IRS basically said that if the trust is designed so that asset isn't included in your estate for estate tax purposes, he's ineligible for a step up in basis.
Okay, well, the type of trust that I generally do are included in your estate for estate tax purposes. I mean, you're basically retaining the asset in your control. You're the trustee, you're the beneficiary during your life. There's only, the other beneficiary is only basically inherit when you die. So it would still be included in the value is included in your estate, and the beneficiaries get the step up in basis. Okay. Oh, wait, hold, could you go back for a sec? Yeah, so as John said, I mean, there's opportunities for not only end-of-life gifting, but, I mean, gifting for appreciated assets as a way of lowering your estate, lowering the estate tax. And a lot of this is, I mean, people want to give away money to their kids if they're buying a house or whatever, but I have had people do end-of-life gifting basically to lower their estate. I had a gentleman probably about 8 years ago who had like a, I don't know, maybe $5 million estate, and he had a lot of it cash, and he was sick, and his son was his power of attorney and controlled all his funds. And during the last couple months of his life, because a lot of the money was in cash, the son was able to give it to himself and the 3 siblings and get about $2 million out of dad's estate, and lower the estate tax, the mass estate tax, quite a bit. And it was just cash, so it wasn't like he was selling anything that was appreciated. He was giving away cash. But most of us don't have a couple $1 million in cash. But if you do, all right. So here's the happy families with an estate plan. All right. Okay. Here, John, help me with the pictures, as you can see. So we're kind of morphing a little bit over toward the gifting, which was a part, but this is going to be a little bit more about that. So planned gifts, any kind of gift that, you give during life or upon death as part of an estate plan is usually called planned gift. You could change it.
Oh,
So I've alluded to some forms of gifting, like charitable trusts. I'll talk a little bit more about donor-advised funds. Could also name charities, nonprofits as beneficiaries on various types of assets. It could be done during life, or it could be done with assets that pass when you die. A planned gift can be really to any 501c3. Usually means it's planned, it's not done like, I'm just going to write a check, but it's done as part of a plan for a family or for an individual. And really any size. I mean, I've been working on a estate for about a year and a half of a woman who didn't have any family, she didn't have any kids or spouse or siblings, and she named me as trustee of her trust. And she was diagnosed with pancreatic cancer, and it happened very quickly. And she didn't really give me direction about what charities, like she had a lot of money and it was all going to charity. And I said to her the last year of her life, like, give me some advice, tell me what you want. Tell me, like, I'd like to give away money, but, give me some ideas. And all she said was like, no hospitals, no universities. I don't want to go into a black hole. So it's been kind of interesting to be giving away all that money. But, and some of it I've done like a 5,000, and some I've done just did for pancreatic cancer. This group called PanCan, in her situation, I gave it to 500,000 to this one. I get to shake all these hands on Tuesday night when I give them the check for $500,000. They have a conference here this week. Okay, next. So if you want me to be trustee, I'm good at giving away money. I mean, it's been amazing. I mean, I did so much research. I tried to figure out what she had done in her life, which wasn't a lot. She worked really hard and didn't give away a lot of money, but anything that she'd given to during her life, I was able to make sizable donations to. But then I had to try to figure out what she would have liked from what I knew about her, talk to her friends. All right. So planned giving can be something as simple as, $50,000 to First Parish in your will or in your trust. It could be setting up a charitable trust, which, as I said earlier, I'm doing less of because there's a cost of setting it up, and then there's an ongoing cost of someone managing it. Foundations, I mean, I've done that, setting up a private foundation. Those are obviously more complicated forms of planned gift. IRAs, RMDs, so you could just give your annual required minimum distribution on your IRA to a charity on an annual basis, because you pay the income tax and maybe you don't really need that money, so you give that to, you just forward that to the First Parish, and they get it tax free. You could also name a charitable organization, or more than one, as the actual beneficiaries of your retirement accounts when you die. So those go directly to the organizations that you name, and they don't pay the tax that any other beneficiary would pay, because that's pre-tax money, your IRAs. And if you name your kids, they're going to take it, and they're going to pay an income tax just like you do. The charities don't pay that tax, so you can name those beneficiary directly. Charitable annuities, that's like the charitable trust. Okay, we've I think we already did this one. Okay, I mean, IRA RMDs are a great way of making charitable gifts, because the cost to you is is lower. And you know, especially if you don't need that as part of your retirement. It's great benefit to the charities. They get it all if they're not paying the income tax that you would. And it's easy. It's easy to do. You just talk with, you know, whoever's holding your retirement account, or the charity can help you with that, whatever it is. And it can be done year to year, or you could do it, you know, on an annual basis where it just automatic goes to whatever organization you choose. Is anyone familiar with the donor advised fund? No? Okay, so donor advised funds, it's relatively new. They've been around for probably, I don't know, 8 years, 10 years? Longer? Wow, I don't think I heard of them until maybe 10 years ago. Well, there's a lot more now than there used to be. So donor advised funds are basically a way of, like, let's say you give away $20,000 a year to charity. You can put that $20,000 into a donor advised fund at any time during the year, and you get the deduction for that year, and then you can choose as you go along what the charities are. So it comes right out. You write a check right from your donor advised funds. So there's donor advised funds with Fidelity or Schwab or Vanguard. They have, and then there's some nonprofits that I think have their own donor advised funds. There's a lot more now, like maybe Boston Foundation or some others that administer them. So basically, you get the tax deduction as soon as you put the money in the donor advised fund, but you can use it as kind of a vehicle to give. And you could do that also in your estate plan. So I do have people who have a donor advised fund that they fund during their life, and then that they name that donor advised fund as a beneficiary in their trust or in their will as well. And you could go to any qualified charitable organization that you direct it to, and it's pretty easy. I mean, clearly, organizations, nonprofits like First Parish. I mean, so many organizations depend on the generosity of people during their lifetime and upon death too, to help to continue the work that they do. And it's, you know, it's also a great example I think for kids and for other beneficiaries when it's part of your estate plan, when it's not all going to, you know, the two spoiled kids. I'm speaking for myself. Okay, so yeah, I mean, any kind of gift. I mean, you could give your house to, you know, you could really give anything to a charitable organization for a planned gift. You know, the simplest are probably retirement accounts, and other appreciated assets are really good too. Any kind of stock or anything, because again, they don't pay the capital gains tax. All right. So this.
I could talk about this slide again.
Okay. John could talk about this slide. I gave this presentation also very similar at my synagogue a few years ago. So, and was this slide? Did you add this slide, or did I have this slide?
I added it with.
You augmented it. Okay.
Yeah, go ahead.
Yeah. So, I mean, clearly it applies to really anything. I mean, I've been practicing, like you said, since 1999, and I've worked with a lot of people from First Parish here, and I'm surprised actually how many people from First Parish have included First Parish in their estate plan. You know, mostly small amounts, but large amounts are, I'm sure, also welcome. But I think it's, in general, a very philanthropic and thoughtful group of people. So that's my...
Just want to make one quick comment. I used to be the play giving director at Smithsonian Institution, George Washington University. So when you're giving to those sorts of places, take just a tip to talk to the representatives of the organization, because they can really help you to fine tune what you do. You know, you might want to leave, let's say, money outright in Sick First Parish, which is great. But you really want to leave it outright to the university that's going to use it however they might choose, or do you want to set it up for that scholarship with the English department, which changed your life, or the art department, which really needs the funds. So just in one comment to really talk to those individuals at the organizations that you're looking to support through the state.
Yeah, I didn't mean to disparage universities and hospitals. I mean, and I do have a lot of people in fact, the fact that I gave a bunch of this woman's money to this pancreatic cancer research organization, even though she said no hospitals, I mean, it's earmarked. And, you know, I think you have to think about what's important to you or what's important to her. In her case, her father had died of pancreatic cancer. And so you have to try to figure out what's meaningful and how to best achieve it. And I tried to respect her wishes, but also try to be practical. All right, is there anything else? Yeah.
I have a general question.
Huh?
Is it more advantageous for, say, your life insurance policy or your fidelity account beneficiary? Is it more advantageous to make the estate the beneficiary?
Never an estate. Because then an estate, as opposed to trust, goes for probate. If you have a beneficiary on your life insurance, a spouse or kids, it's very readily available to them when you die. If you name a trust, the trust is already in existence and it is also very readily available. If you have my estate means probate. You have to probate the will, you have to wait through that process, and there's a delay, and there's no advantage of naming an estate as a beneficiary on anything, in my view. Yeah. Question in the back?
Yeah, my wife and I did all the will and trust things probably 10 years ago, and of course we haven't funded the trust. But if that lawyer retired,
Mm-hmm.
so if we want to get it updated and we go to a new lawyer, do we have to start all over again, or do we just update what we have?
Well, in my opinion, it depends. I mean, was it done in Massachusetts?
Yeah.
So generally, I don't like to amend other attorneys' documents because you're taking on whatever mistakes they may have made. But I do. You know, I got one recently. It was done in 2017, and it was actually from another state, and I hardly ever will amend documents from another state, but it was really, really well done, and it was not standard, so there was, like, his and hers were different, and there were different assets that were passing right from her to the kids, whereas in his, everything went to her. So in general, it's a case-by-case basis. Age is a factor, where it's done is a factor. Taking a look at it for me, because I've been doing this for 25 years, is it going to take me longer to read through that and make sure that I am comfortable with everything and do an amendment? And if that's going to take me longer, I'd rather do my own document because it's going to cost you less and I'm more comfortable with it. And when you do a new trust, and I don't know if it sounds like you haven't funded the trust, but even if you had funded the trust, when I do a new trust, if it's funded, the old one, I do it as what's called a restatement, which means that if you already have it owning real estate or already have it as a beneficiary of life insurance or retirement, you don't have to change those because the new one is a restatement of the old one with the old title. It's kind of a technical thing, but when people fund their trust, the process of funding the trust is often takes work for the person doing it. Because like I said, if you walk out my door and you've done trust and you never change beneficiary in anything or never incorporate the trust in your asset ownerships, some of the benefits of the trust are still going to work, like your kids will still get the payments staggered, but the avoiding or minimizing the cost and delay of probate, you're not going to get that benefit. So in answer to your question, it would really depend on the trust and what it looks like. And the estate tax rules have changed too. So 10 years old. So the fact right now that Massachusetts exemption is so much lower than the federal exemption, sometimes in trusts, in order to, this is going to get really geeky, in order to totally avoid all estate taxes, there's like a trust that is a sub-trust and a trust that captures the first $1 million to make sure you use your exemption. The first spouse uses their exemption, so the kids will get, or the other beneficiaries will get the exemption doubled. And then the next above $1 million is treated differently because the spouse can have free use of that. Depending on the age of the trust, there may be, if Massachusetts and the federal exemption were the same rather than different as they are now, there may be different language in the trust than what I would use now, because it's what's called Massachusetts is a decoupled state, where the federal and the state exemptions are different. Some states are coupled. The state exemption is the same as the federal, and Massachusetts used to be, the federal and the Mass were the same, but that was more than 10 years ago. So yours is probably okay in that regard.
I think I'm convinced on the value of wills and trusts. But I also look at what you get on sure that where you get powers of attorney and help processes and wills for free or short dollars. Why would one spend money going through a legal firm and it's available low dollars on the internet?
So those are okay. I mean, if you're pretty straightforward and simple and standard and adult kids, it's way better than nothing to have. And I've looked at people. People have asked me to review stuff that they've done, and I've done that a couple times, and they're all right. The main reasons are, I think, because first of all, especially if you're going to do a trust, what's trickier about the trust is to make sure that it's incorporated correctly into your asset ownership and beneficiary designation. And it's harder to do, I think, if you do it yourself. I mean, you probably would end up not funding the trust. If you're going to do basic wills and powers of attorney, healthcare proxy, and you have a fairly standard situation, yeah, it's not bad. Mostly. I mean, I've only looked at a couple examples. Yeah, it's way better than having nothing. But I think it's mostly the follow-up stuff. It's also when you work with a lawyer, they look at everything. So, make sure that the beneficiaries of your retirement accounts, are consistent with what you want. Because sometimes people want certain, maybe their kids and some other person to get it, but the beneficiary designations are not consistent with what's in the estate plan. So you kind of have to look at the whole picture. So I think that the main benefit is just to have everything coordinated and have someone look at it. But the documents themselves are okay. I think, they're done by lawyers. They're standard. I'm sure they're legally binding. They have all the required parts of them. So it's really more if it's like a more than a will situation that I don't think those are going to be very good.
We have an unfunded trust.
You and most people.
What is the precise procedure for moving, for doing?
For funding the trust?
Yeah. I mean, we have a retirement account.
So, I mean, I would have to sit down with you because maybe your retirement account, if your beneficiaries, do you have kids?
Well, yeah.
So if your retirement accounts name, are you married? If your retirement accounts name each other and then the kids as beneficiaries, then that's not going to go through your trust, and that's probably fine. That's probably better. I didn't get a lot into the distributions for retirement accounts. I mean, if you name a spouse as beneficiary of your retirement account, they take it out over their life expectancy, just as you do. So you look at the actuarial tables and you take the required minimum distributions or more if you want, and you pay the income tax, right? I mean, that's what you have to do with a retirement account. If you have your kids named as beneficiaries and they're adults, they have to take distributions out over a 10-year period. It used to be they could take it out over their life expectancy, but they have to take it out over 10 years, which means they pay the income tax as they take it out, just like you do. They could take it out all in year 1 or all in year 10, or equal distributions over 10 years, but they have to take it all out by year 10. If you name a trust as beneficiary, it's probably also the 10-year rule, but the rules are very different for retirement accounts. As far as other assets funding your trust, if you have brokerage accounts that are not retirement and you wanted to, generally, if I was working with someone and they had brokerage accounts that are non-retirement, that are after-tax money, you can actually be retitled in the name of the trust during your lifetime. You're the trustee, I assume, of your trust, so it doesn't really change anything. To his question, it doesn't really change anything. It's still your asset. Any income still you pay comes out in your 1040, but upon, and I don't know if you have a joint trust or individual trust, upon the second death, then the trust becomes a separate legal entity. The trustee has to apply for a new tax ID for that trust, and then then income comes out at the beneficiary to the beneficiaries. So, your trust should probably be funded. I don't know why it wouldn't have been. How long ago was it done?
I don't want to talk about it.
Okay, well then, yeah. Probably needs a review anyway.
I want to go back to the Massachusetts estate tax.
Oh, my favorite topic.
What am I? My understanding from when you covered this topic was that if your assets are in a trust and the trust determines what happens to them after you die,
Right.
are they indeed then, as a result of that, protected from the Massachusetts estate tax?
No.
Oh, I really don't like that answer.
That's the truth.
Is there any way, really the question is there any way to avoid Massachusetts estate tax?
Move to New Hampshire. No, I mean, an irrevocable trust. So the type of trust that I was mostly speaking about were revocable, where you continue to control that. You are the trustee and the beneficiary. If you want to control that asset and have use of it during your life, it's going to be part of your estate when you die, whether it's in a trust or not. The only way of not paying the estate tax is to basically give away that asset, to put it in an irrevocable trust. But I talked about the step up in basis. You don't want to give away or even put in irrevocable trust highly appreciated assets where your kids, you don't want to have the tail wag the horse. So yes, there's an estate tax, and it's between 7 and 12%. It's graduated. But if someone's getting your house that you paid $50,000 for, and now it's worth $1 million, and they have to pay an estate, I mean, I'm not against taxes. I'm just not. I think here in Massachusetts, it should be, in my opinion, it should be higher because people will leave because of it. But I don't know, you get what you pay for. But you also get the step up in basis. So yes, as an estate tax, there are ways of minimizing it. Like I said, if you're married, by doubling it. You could do gifting during life. As I said, even large gifts if you want. And you file a federal gift tax return, it lowers your mass estate. But you don't want to give away appreciated assets. You only want to give away cash. So there are ways of lowering it without moving to New Hampshire. But they're mostly somehow losing control, giving away either outright or in a trust assets. Not the answer you wanted.
I just have an observation that I want to pass along. You want to qualify it. That's
Okay.
I inherited an incredibly complex trust situation for a nephew with disabilities, and learned with this whole lesson possibly $30,000 to be movies across the trust wheel. In some states, in fact, probably in most states, if you leave a trust to someone who is getting Medicaid benefits, depending upon how that trust is set up and funded, the state can come after those assets to pay back what they paid out on Medicaid benefits, so they can completely deplete what you leave to them. So check it out with a professional. This is in Vermont. circumstances different. But as something you do is leaving third-party money in a first-party trust.
Yeah. Third party, that shouldn't happen. Yeah. Yes. Medicaid trust, I mean, that's one of the reasons why I try not to touch Medicaid. But, and you're talking about also, and I didn't mention this at all, supplemental needs trusts, which I alluded to, like a trust for people with special needs. You know, if you have a handicapped child or nephew or niece that you want to leave money to, you really want to do it. You don't want to do it outright. They could lose benefits. You want to do it in a trust, but you want that trust to be written correctly so they do not lose benefits. Sometimes there can be payback, but the most important thing in many situations is that they don't lose benefits. They don't lose their health care. They don't lose housing, whatever it is. So any kind of beneficiary with who gets disability or who may get disability, you don't want to leave assets outright to them because what they could lose is worth way more than what they could gain from an inheritance. Sometimes you don't even want to leave them anything because healthcare benefits are pretty much like critical. Any other questions?
One comment, Ellen, and it's much your thing. About 10 years before my parents passed away, I started getting involved in their affairs, and they hadn't funded their trust in the 10-year period. You got everything in it, and it was so smooth at the end. And it wasn't that hard to rethought, Barbie was saying.
I want to know, do I call somebody and say, here, change the title of this thing?
I'm not going to say because it sounds like your trust is really old, so I am not. It's only a year. Oh, okay.
We just haven't done anything about it.
Well, I would go back to the attorney and ask them, did they give you instructions on funding the trust? Because that's something that the attorney cannot do other than I could do a new deed. I could put if you come to me, you know, and we decide that you're going to have a trust and that house should go in the trust, we file the deed. But I can't change the ownership of your accounts to the trust or change the beneficiaries. That I put in a letter when you leave my office or we talk about it, and then I put in a letter, this is what you need to do. You're not done when you walk out the door. You still need to do 1, 2, 3 to fully take advantage of what you've done. That's, not all lawyers do it the same way, but that's, you know, see if they gave you some sort of a follow-up letter or some sort of follow-up instructions.
I want to thank Barbara again for coming. No other questions? Yeah, your writer's wall. That was really excellent.
If anyone has anything that they want to ask me, hello, feel free to come up and.
And don't forget, the next Sunday, seminars in a series. Katie over there next week during Medicare and Chesapeake's. The following week, Lori, we're still here, maybe.
In the back.
Options, and Lori in the back. And last week, Tom Moses with Senior Services available in the area. So the next 3 Sundays, place by Hodge. And thank you all, and enjoy it before you go. We're all meeting the best.